So thank you everyone who is here on person and the people online who are hopefully not deterred by our late start. Just to kind of explain to people online who may be like, what's going on? We had a fire drill in the building unexpectedly right as this event was starting. So we're getting off to a late start. Sorry about that. But not even a fire drill can stop the Center for Business Law. So we will continue, and we should have plenty of time for Doug's presentation and for questions after. So again, thank you everybody for sticking it out here. My name is Camden Hutchison. I'm the director of the Center for Business Law. I'll just give a very brief introduction to Doug so we can go ahead and get started. Doug Chiu is a partner at Hammerco Lawyers LLP. He has a very diverse practice, which includes commercial litigation. And within his commercial litigation practice, he has quite a bit of experience of dealing with culturally diverse and ethnically diverse clientele. And he's going to be talking to us about some of the strategies and some of the sensitivities and nuances that you need to be aware of in order to, most fully and successfully represent those types of clients. So without further ado, I'll let Doug go ahead and get started.
Thank you, Professor Hutchison. I hope everybody can hear me. I hope it's not like foreshadowing something like where first time I come here in a while, there's a fire drill or something like that. So hopefully everything goes smoothly and hopefully everything goes well. Thank you for the intro here. I just want to talk a little bit about the title and the topic. Obviously the title is Diverse Clientele and Litigation. I just want everybody to know the word diverse and the word diversity can mean a ton of things. It can mean, ethnic group, cultural group, sexual orientation, indigenous, whatever, whatnot. I'm particularly going to talk about a specific cultural group where I'm a part of and also where a lot of my clients are, right? And if it's something to do with another group, unfortunately, I may not practice in that area, but I do know of counsel and other lawyers who do. And if you want me to get in touch with those for you, I'd be happy to do so, right? So I'll get started here. Just want to give you a bit about ourselves and my firm to give you a good understanding of not just what I do, about what we do, and hopefully it blends into the ethos of what I'm going to be talking about. We're Hammerco Lawyers. We are based in Vancouver. We've been around for 25 years. We are characterized as a litigation boutique. So we have 12 lawyers and all we do is litigation. We're trial lawyers, which basically means we do things where you may see on TV, all right? So all the shows that you see where you have a courtroom, you got a judge, you got a jury, you got witnesses, those are the trials and those are the courtrooms that we appear in front. We're not appellate lawyers. So understand that some of you might be involved in moots. Most of those are appellate moots. We don't do those. We don't go to the Supreme Court of Canada. We're not involved in provincial court or the CRT. All our cases are in SCBC. We're trial lawyers. And we are primarily plaintiff focused. And if you can tell that by the areas of law that we do. So we have a class actions practice, for instance. We represent people who have been injured or hurt by doctors. We act for people who have unfortunately been sexually assaulted. We are hired by people who have maybe disinherited as part of their wills. We act for people who have been unfortunately injured. And I lead my practice group, which is commercial litigation. I've been a lawyer for, 19 years now. I was here, or the remnants that was here I was class of 2004. My 20th reunion is coming up, I believe this Thursday or Friday. Unfortunately, I can't go. I'm dating myself, but I don't mind, right? Okay. So it's the Center for Business Law, and I was sort of reading your advisory council, looking at some past events that you guys have been a part of. Undoubtedly, a lot of solicitors, but there is a litigation component to business law, and that's what I want to talk about today. And when it comes to litigation, understand that this is probably the difference in that a person who comes to see me, something has happened. And usually that something is bad. It's something that's negative. So it can be somebody where they've been hurt and it's not their fault. They have been written out of their parents' will. They have been, somebody has taken money from their company or something like that. A person will come and see me because they have a specific problem. It's not to get a deal done. It's not to buy another company. It's not to form a contract. A wrong has occurred, whether it's right or whether it's wrong or whether it's proven later on in the day. In terms of litigation, keep in mind that when it comes to a deal, obviously there's a timeline attached to it. There's probably a date for possession. There's a date for closing. We are strict timelines in terms of the rules of court. And you will learn this in your civil procedure class. So we're governed under Supreme Court rules where things have to be filed by a certain time. Certain things have to happen by a certain date. Certain pieces of evidence have to be given to the other side. Again, strict timelines that we have to abide by. But there is some flexibility in calendars. So when I take a look at a solicitor's practice, if a deal closes on Christmas Day, unfortunately the deal is going to close on Christmas Day. Courts do not open on Christmas Day. Courts do not open on Boxing Day. They don't open on statutory holidays. I can legitimately say that, so around December, maybe sometimes around in the summertime, a little bit less busy, but specifically September, October, January up, a lot busier. And that's because you have to take a look at 3 different calendars. So you take a look at my calendar, opposing counsel's calendar, and obviously the court's calendar to schedule things. So there is a little bit of flexibility in your calendars. When people, if I talk to my mom and dad, and they're like, okay, what does a litigator do? They probably think of what they see on TV, right? So they probably think of it's somebody in the courtroom, it's somebody that's really argumentative, somebody that talks a lot, somebody that argues, and it's really, really combative almost at the end of the day. I would say this, though. I would say litigation, it's basically a constant risk assessment with the possibility of negotiation. But at the end of the day, if we can't come to an agreement, there's a court process that's able to handle all these things. So it is not butting heads all the time. So a lot of the times, I would say most of the time, what my job is, it's literally risk assessing. So I have a client, and we tell our client that, in our opinion, your damages are likely going to go from here to here. This is probably the minimum you're going to get if it goes to in front of a judge or a jury. This is the maximum. And then on the other side, they might say, you know what? Doug's case, I can see it being from here to here or nothing at all. I don't think he has a chance. So it's always risk assessing. And as each stage comes up, more evidence is presented, you get more testimony, you get to see what people are like in terms of when they're presented with questions and answers, and also, of course, counsel's skill. You constantly risk assess. And very few cases go to court. And the reason why is because it's so expensive, it's so pricey, extremely stressful. So if there is a time where in the middle of the case, the other side is offering an amount that is nearly 100 cents on the dollar in their best day of court, my job is to tell the client, you should probably take this because you're going to be risking a whole lot more in front of a courtroom. But if nobody agrees, or we don't get to that stage where both sides are just so far apart, that's why there's a court process to deal with all this. So again, a lot of risk assessment, a lot of negotiation that's going on. It's, in terms of litigators, good ones that I have worked for, worked with, worked against, I can say that these are the traits that I have learned the most from. Again, the perception is litigators are very good oralists, right? And they should be. But I think it's also important to be really good listeners, too. So if I have a client, for instance, who's telling me their story, it's my job to listen to them, and maybe there's something that they're not telling me yet. I can feel that there's something that's not there, but it's my job to closely listen to them and say, okay, like, what about this? Or what about that? Have you thought about this? Conversely, on the other side, if I'm in the middle of an examination for discovery and I'm asking questions to the opposing party, I try not to follow a script, right? I listen to their answer, and maybe they're giving an answer that can, lead to more, that can dig them deeper, that can test their credibility a lot more, that can give me more facts that I haven't been aware of. Again, it's listening. obviously this goes for both solicitors and litigators, meticulous preparation. And what I mean by this, it's like when somebody gives me an answer or I'm discovering something, I can sort of remember, hey, does that match up with the document that I have? Does that match up with this email? Does this match up with this photograph? I remember this person saying something in their transcript. Where is it? So just to be prepared and know where everything is really, really helps. Flexibility, and what I mean by this is that your cases turn. So if I think I have a great case right now, maybe 2, 3 months, 1 year down the road when more stuff comes in, my case isn't that great anymore, or something has happened which has caused more risk. So I have to be flexible in terms of, hey, I have to find a new argument here. This road is closed, or maybe the law has changed, right? Maybe there's a new precedent that's been given out that completely quashes this argument. Okay, what's the next step here? And most importantly, I think the key trait is the ability to forecast and anticipate your friend's argument. So me sitting there, I'm not just thinking about my client, I'm thinking about all the contingencies and all the arguments that opposing counsel can bring. And if I can cut them off right at their knees before they bring that up and say, hey, there's this new case, or hey, what about this? What about that? I know you're gonna say this, and this is my answer. It's super effective, not just in a courtroom, but also in a negotiation setting too. So I'm here to talk about diverse clientele and litigation. And again, I'm not a sociologist by any means, but I do want to pull up some stats. Obviously, I practice in Vancouver. So these are some stats that I pulled. 55% of Metro Vancouver are a visible minority. I'm looking around in this room right now. I think that represents that. 34% of Metro Vancouver speak a language other than English. So again, quick show of hands here. How many people here in this room do? I do. Okay, a little bit more than half, to be honest. 42% of Metro Vancouver are foreign born. Again, if you don't mind, quick show of hands. Yeah, roughly about a quarter or so, right? So we're close. So these are the demographics of what Vancouver is like. For me, I'm not going to talk too much about myself, but I do kind of want to give you guys a little bit of a background here. Born in Vancouver, parents are immigrated from Hong Kong. I'm first generation Canadian, first generation lawyer. 80% of my clientele for the past 19 years are either from Hong Kong or from mainland China. And they typically communicate not in English. I've been very lucky. So I can speak English, obviously. 我識講廣東話. I can speak Cantonese. 我可以說國語一點. I can speak a bit of Mandarin. Posso parlare in Italiano. So I can speak Italian too, right? So again, this has sort of helped me communicate with my clients. There are days where I speak more Chinese than I would in English. Yesterday was a perfect example. Every single phone call that I made, all my client meetings were all conducted in a language other than English. These are people that I act for. So I've acted for, honestly speaking, probably thousands. Personal clients, and in terms of corporate business clients, mainly family-owned small and medium-sized businesses. I've never acted for like a large bank. I've never acted for like a big insurance company or like a big, something that's listed on the TXS or something like that. It has been mainly family-owned small and medium enterprises. So these are retail stores, these are professional offices where they provide their income for the family that they go home to. So when I talk to my clients, especially the first time before they come in to see me, you start to realize that there are some perceptions. And whether these are right or wrong, this is what I've been told by my clients, and this is what I've seen with my own eyes as well. So we're all here in law school. There's a number of, let's just say, Canadian perceptions. Obviously, we have a belief of there's a rule of law, right? There's statutes, there's laws that everybody has to follow. You're proven beyond a reasonable doubt in a criminal case. You have to prove your case beyond a balance of probabilities in a civil case. Simple. there's a belief that there is a separation of state. I put a question mark after that because, jokingly, that might not be the case right now. The NDP is trying to get rid of the Law Society. They're trying to make lawyers not self-regulated. That's a whole different discussion. There is an idea of fairness and trustworthiness. So you believe in the judge, you believe in the lawyers, you believe in the process. There is an idea of accessibility. And again, I'd not jokingly put a question mark there. There is an issue of access to justice, but there's pro bono work, there is legal aid, may not be the best, but it's at least deemed to be accessible. And most importantly, lawyers are put in a position of trust. I have a fiduciary duty to all the clients that I act for. On the other hand, this is what I've seen and this is what I've been told. A lot of my clients have come from a background that's more authoritarian. They come from a background where the legal system might not be for everyone. It might just be for a certain class. It might be for a certain elite, for example. Some of them have the perception that it's untrustworthy. Judges are bribed, prosecutors are bribed, police officers are bribed. They have an idea that it's inordinately expensive. It's too pricey for me to take part of it. And lastly, and wrongfully, they have an idea that lawyers are hierarchical, so that we're put on a pedestal. There's been many times where clients have been afraid to see me in my own office. They don't think that, for some really silly reason, they don't think that they're worthy enough, right? So you kind of have to calm them down a bit and say, nope, we're here to help. We're here to see what's up, right? Again, these are perceptions that they might be coming from. So what I want to do is I actually want to take you through an ongoing case study right now. This is an actual case that I'm involved in. This is an actual case that I'm working on. It's in the middle of it. No decision has been made. Everything is still alleged. There's been no settlement, nothing like that. And I'll give you some background. So this store here, it's a lighting store, all right? And what they do is they're completely retail. So they sell residential and commercial lighting. Everything from as small as a light bulb to everything as large as a gigantic chandelier. So that's what they sell. And my clients, the people who own this business, it's a family. There's 3 generations here, all Chinese. And not only are they shareholders, but they also work in the store. So not only do the shareholders work in the store, their spouses do, their children do. So again, it's just this big family business. It's legitimate. It's been there for more than 20 years, same location. And it is successful and it is popular, that's undoubted. And more importantly, it's especially popular amongst other Chinese businesses. So it's a place where, let's say there's a developer, they're building a 200-room complex. They will go into the store and say, hey, I want this light fixture for this kitchen times 200. They will go, if you're a renovator and you're renovating a person's home, again, you'll go in the store to look for things. Myself, even, this is true. I need to renovate my kitchen. I asked my dad, hey, I need a chandelier. Who should I go to? He recommended me this place. So again, this is like family-owned business, a reputation amongst a certain community. So as you can see here, before I go there, it's a 2-story store. So they have retail on the bottom, they have retail up top, there's some office space to it. So what happened was this. In August 2020, immediately next door to the west of the property, so you can see that part of the yellow there, that's my client's store. So this gray building, that was built starting in August 2020. So the owner-developer, they built this giant building. And what happened was that shortly after, there were cracks. There were cracks on the outside, there were cracks on the inside, there were cracks in the foundation. And the city had to condemn my client's building for at least 3 months. So safety reasons, my client was out of business. Nobody can enter or walk into the building. Things happened, there was a flood even, things were damaged, but essentially That is what happened. It has reopened since, but even to this day, 4.5 years later, it's still undergoing renovations. It's not finished yet. I've pulled up some photos, and these are actual photos that I have disclosed to the other side here. You can see the cracks. That's from the outside. That's from the interior there. So you can literally see through from the inside of the building to the outside. I'll turn back here to a few other ones. If you can go to that far right, you can see there's like a pole leaning against the yellow wall there. There are like 4 of these outside and 6 of these inside to literally hold the wall together, all right? That is what's going on, literally as we speak today. Here's the foundation. Again, cracked, ruined, had to be repaired. So this is what we're alleging. Again, nothing has been proven yet, but this is what we're saying has done wrong. So we have sued everybody involved into the project for negligence, that they committed, not on purpose, but they committed a wrong that has done damage to my client. And this includes the developer, the general contractor, the shore, the engineers, the city, anybody who we believe is involved in this project. So if you can imagine, there's one plaintiff, and I think in this case, there's like 9 defendants. So it's 1 versus 9, there's 9 lawyers on the other side. And the reason why we have so many defendants is because we believe each one of these has a specific purpose and it did something wrong. But it's also the idea of vicarious liability. For those in 1L, you will learn about this. Essentially, the principle is even if you're found 1% liable, you may be responsible for 100% of the damages. So what we do is it's not just 1 versus 9. I think I'm being too basic when I say that. What happens also is the 9 of them fight against one another. So they're like, you did this or you did that. I'm only 20% at fault. You're 30% at fault. So you try to get everybody in the same room. They're fighting each other to decide how much eventually to pay my client. There is also an element of trespass to this too. So if we can go back. So on the other side there's like a little bit of a driveway. And under CCTV, my client's own security camera, they found footage of like the developer's big crane. So imagine again, like a big vehicle with gigantic tires, and they would use this crane to lift up pieces of wall to put on their property and to put on their building. And they found this crane, they were actually using this crane on my client's driveway. So instead of going from the street, they were parking it on my client's driveway, the weight of it lifting up their stuff to use for their building. No consent was given, we're alleging trespass. And this is the losses that are needed to be proven. So these are things that I need to do to prove each of these laws. So we're saying that obviously our client's business has been affected, so there's been a loss of profit. Stock has been damaged, so things within the building, items that they're intending to sell, has been damaged. There's the ongoing cost of repairs. My client has insurance, but insurance only gets them to a certain point. There's everything past that too. And most importantly, there's also a loss of goodwill. So this retail store, it's situated in an area where there's like tons of other sort of like renovation stores. It's by an IKEA, it's by a Home Depot, there's other lighting stores nearby, there's plumbing stores nearby. So it's kind of like this renovation district. So obviously it being closed for so long and not meeting its business for this long, there's been a loss of reputation and there's been a loss of goodwill. So if I go into a Home Depot and I want to buy a chandelier or something like that, the store is clean, the store is nice, service is good, I can walk around. I go into this store today, there's these pillars lifting up the walls, things are everywhere, it's like walking through a construction site. That's why we're alleging loss of goodwill, loss of reputation. This is, I'll take you again from the start to where I am today. So how did I first meet this client? So very few of my clients come from like a Google search or a Google review or through a Google ad. We have clients that do, very few of mine do. So they're not looking for like a restaurant or not looking for a hotel review or something like that. This was found through me, through some pro bono work that I do. Once a month for the past 14 years or so, I've been on Chinese radio. And what they do is basically for an hour on a Saturday, me and the co-hosts, we provide commentary. So I find interesting cases that I can talk about in Chinese to my audience. And we do take in some live callers, so it's pretty fun. You get the odd funny question where you have to answer on the spot. But I've been doing that for so long where they found my name and they gave me a shout. So again, it wasn't through a direct referral, wasn't through the internet. It was pretty organic, to be honest with you. I talked to them on the phone, understood where they were coming from, and I understood that this was a family business. I knew that pretty much right away. So we decided to have our initial meeting in my office. And instead of me asking for one person to show up or two people to show up, I told them, I was just like, hey, whoever you want to be involved in this meeting, please have them come. And ultimately, I think 6 people showed up, all related in some way. Grandparent to grandchild, second generation, third generation. And one of the things that happens in cases, this wasn't the first time where a whole bunch of people showed up in an initial meeting. One of the things that I had to emphasize at this meeting is, okay, I need a contact person, if not 2 at the most, because I don't want to give 6 different answers to 6 different questions at the same time. So I don't want to tell somebody one thing and then repeat that to 5 others down the road. I need 1 or 2 contact people, more than happy to talk to you guys about that. And I also emphasize, in this case, it wasn't that bad, but I also emphasize, my role of confidentiality too. So things that I tell my client, obviously I can't tell any other family members. I'll give you a better example, and I clearly remember this. I was a way younger lawyer back then. It was a personal injury claim. So I acted for like a patriarch, like a grandfather who was involved in a motor vehicle accident. And I says, yeah, for sure, you can come and see me by all means. And I thought one person was going to come and see me, or at the most 2, a person and their partner or their spouse. Again, I am not exaggerating to you guys. 15 people showed up at that meeting. 15 people. So it wasn't just my client and his wife, it was his kids, it was the daughter-in-law, the son-in-laws, a couple grandchildren, everybody came, right? And I was not expecting that at all. But again, this happens. And I clearly had to say to them, I was just like, hey, your grandfather is my client. Your dad is my client, right? So I can only talk to your dad or your grandfather about his issues. Don't call me and say, hey, how's this case going? Or has it ended yet? Or has it resolved? And for how much or for how little? I can't talk to you about that. Your grandfather can, but I can't though. So it's something, again, to be aware of. And a lot of cases as well, there's a really inherent fear of litigation. And it sort of goes back to what I was talking about earlier here. I've had people who have been scared to sue the government, sue a police officer, sue a government body, BC Hydro, BC Gas, ICBC, legitimate, or a health authority, legitimate cases, right? True real life cases where they said, is there going to be any repercussions to what I do, right? Like I've answered that question many, many times. And obviously there's not. There's also the fear of this being public. So sometimes you do have to tell your client that, yes, if we file your action in court, everything is public, right? So they will know the names, they will know what happened, they will know what the defenses are. And if this case goes to a courtroom, again, everything is public. Any one of us can walk in and watch this trial or read this judgment. Yeah, there's an element of maybe embarrassment and shame. Like I don't want to cause trouble. I don't want to stir things up. So it's sometimes I wouldn't say convincing, but you do have to say, hey, these are your legal rights. This is what you're entitled to. Is this something you still want to pursue? So talked about the point person, but sometimes I have clients who think, okay, I've hired a lawyer and the lawyer can do everything for me. So it's also really important for me to tell them, what is my actual scope of work? So nope, I'm not going to show up when the city comes. I'm not going to be there when there's an inspector that's going to show up. I'm not involved in terms of the accounting. I'm involved in your actual legal case of anything to do with anything with the defendants. But when it comes to other people and other issues, I will not be there for that. Again, mentioning the scope of work beforehand, really important. There's also the boundaries of communication. So not all my clients can type in English. Not all of them can text to me in English. A lot of them prefer WeChat. A lot of them prefer WhatsApp. A lot of them prefer voice texts, right? And it's usually in another language, right? I basically almost always say to them, if you can send something to me by email, that'd be great. And the reason why is that easily documented, I can easily find it, and if it's necessary, I can also list it too in my list of documents. It's just easy to have. Boundaries of communication as well in terms of when do you get back to your client? So sometimes, and they're not taking advantage of you. Maybe they just don't know, right? So you do have to set boundaries. And if they're calling or if they're emailing you on a Friday night or a Saturday or a Sunday, if there's nothing important going on, I would say, yep, I will respond back to you on Monday morning. I'm not going to call you back right now, right away, or respond back to your text message. And I would say nearly 99 times out of 100, they respect and they appreciate that. But that is something where sometimes, don't be offended. If you get a call on a Friday night, right? Okay, something's happening. If it's not important, that can probably wait until Monday. So during the course of the litigation, what happens is that a lot of documents are exchanged. Anything that's relevant that I think needs to be shown to the other side, I have to give to the other side. They do the same for me. And when I'm dealing with cases like this, there's a lot of verbal agreements and there's a lot of handshake deals. Not every contract that is exposed or is written, it's like ironclad. A lot of them don't seek legal advice. A lot of them don't see a solicitor to help them out. So a lot of these are, yep, we have a good relationship now. Let's continue this relationship for 5 years. Handshake, this is how much I'm going to pay you, move on. But obviously something happens, right? So expect that. Sometimes you won't get that contract or something written in paper that really defines your case. Something also is like a lot of these things are not in English. So there are extra costs associated with translations that my clients are responsible for. So we have to translate documents. We have to translate texts. I had a recent case. It went to discovery a couple weeks ago. It was 4 hours of voice text in Farsi. So yeah, and it was over this big dispute, and it was voice text between the plaintiff and defendant, all in Farsi. So I don't speak Farsi, but I had to hire a translator to literally listen to each text and write out in English what each text is. So when it took time for me to discover the defendant about this, you said this, didn't you? You said that, didn't you? And yeah, it all had to be in English. But this happens, and again, this is normal. So during the litigation, it's obviously my job to prove damages, but it's also my job to manage my clients' expectations as well. And this is not the case, thankfully, in this case, but I've seen it before. So sometimes a lot of retail establishments, it might be cash businesses. So there's no paper trail, right? And whatever reason they did that, that's on them, right? But when it comes to their court case, it may have a huge effect on their own damages and what they can actually claim for. They have to swear, whether it's a corporation or a personal report to CRA every year that, yeah, this is all the income and this is all legitimate. But then when you're trying to prove a loss, it will hurt your credibility if you're saying, well, yeah, I reported $100,000, but I actually received $500,000 in cash. I'm owed $500,000. It really doesn't work that way. So something to keep in mind as well when I have to deal with client expectations. I have to manage the bad news sometimes. There's also a difference sometimes when I'm trying to explain this to an opposing party or even to a judge. So I'll give you this example and I'll give you others that I have. So this is what I foresee. Forecasting again. I foresee that defense counsel is going to say to me, they're going to say, Doug, your business closed in 2020 and for 2021. That was COVID. Every single business in this entire world also suffered a loss. What makes you special, right? They're probably going to say that to me one way or another. Okay, yeah, of course I know COVID happened. Okay, but at the same time, guess what? People were stuck at home, and those with incomes were still earning their job. They're working from home now with nothing to spend on. So what were they doing? They were renovating, right? They're building their office at home. They're renovating the kitchen. They're renovating their bathrooms. They're renovating their basement. So self-renovations undoubtedly exploded during the time of COVID. And there may be a situation where, again, my clients' business, it fits a certain niche in their cultural marketplace. So I've acted for, let's say, like an Indian wedding shop, for example. I've acted for Chinese restaurants. Again, these are specific businesses for a specific cultural clientele that we can't compare with to others. I can't compare my clients' Chinese restaurant to Earl's or the Cactus Club, for example, right? These are things that might need time for me to explain again to the other side or to a judge when I'm seeking the damages that I want to prove. When I'm dealing with my clients, so again, my language, I can't explain very minute details in terms of the case to my client. I try to speak to them in an everyday sort of language. So if I have to hire experts, and I do for cases like this, I would need an engineer, I would need an accountant to tell me what the losses are. I'm not an engineer, I'm not an accountant. They're going to write me a report to say, hey, what did the other side do wrong? And Doug, what are your damages going to be? And for me to explain that report to my client, again, good protocol for me to have a translator there. Hard for me to explain business terms and engineering terms to somebody else, that's why. When it comes to procedures in court where my client needs to attend, such as like an examination for discovery or an actual trial, translation costs. They can't have their friend there. They can't have their parent there beside them. You need a court-certified translator to be there. These are extra costs associated with cases like this. There is a little bit more hand-holding, I can say this. So when it comes to like stuff, like an examination for a discovery or for a trial, I sit down with my clients and I say, hey, this is where you're going. And I literally kind of draw them a map. It's just like the courthouse is located here. Parking is here. This is the nearest train stations. This is the nearest, SkyTrain station. Parking is going to cost this much. There are times where I've asked my clients even to meet me at my office, and I will take you there myself. We'll go together. They've been to my office before. They're comfortable with that, and we go together and we come back together. That way, a little bit less stress for them to deal with on that day. So imagine they're going through a process that's completely foreign to them. They're going to be talking about themselves and being asked sometimes very imposing questions by a foreign person, and tons of stress level already. The last thing I want for them is to worry about where they're going to park their car or where they have to meet me at 9:45, right? So easy. Let's meet at 9:15 at my office. We're 15 minutes away. We'll drive down there together. A little bit more hand-holding, but I think it helps. And you do have to explain the little details. You do have to go through, okay, this is what a courtroom looks like. a judge sits here, you're going to be here, I will be beside you. This is where the other lawyer is going to sit. This is where the gallery is. This is the procedure for something that happens. So things that might seem really rote to you, like really common and really elementary, they are not elementary and basic for somebody who's going through probably their first court case. So my takeaways is that a lot more sort of personal service is required, and definitely sometimes a lot more patience is, especially when I'm explaining things. But I can say that it's been extremely rewarding. And because they can communicate with me in their own language, and I can with them, your trust is earned quicker. And what that means is that there is future work, right? If you do a good job, they will continue to refer you files and other friends or family members that they have for you down the future. That's my presentation, y'all.
Well, thank you so much, Doug. And we have plenty of time for questions. I have a couple questions myself, but I'll defer those and let any students go first if they have questions.
Go ahead.
Yes. My question is that what do you think is the biggest difference between litigating for individuals versus businesses?
That's a really good question. I would say this, it's the personal part of it, right? So when I deal with a corporation, be it a small business or a medium business, your loss it's a business loss, right? Your legal fees may be a business expense. So you're sort of compartmentalized in that way. When I act for a person who has been personally affected, like that is their case. So they wake up and they think about their case. They go to bed and they think about their case. That is sometimes the only thing that's on their mind. So there's a lot more lasting effect to it. That's the one thing that I see. Yeah. Go ahead. Sure. So what we do is you can have comparisons. So you can take a look what another business similar to this one that has been affected, how much they have gained during their time versus how much we have lost. So that's one way. So what happens is that I have to give all of my financial information to an expert. It's usually an accountant, and they will go through, these are the potential losses. This is what you can probably prove here. And sometimes the accountant will have background information of a similar industry. So what other businesses were making at that time, compare that to yours. Sometimes the best piece of evidence is like a direct competitor. So if they're, or not even a direct, like a synonymous business. So if something is as close as possible to what I had, and they were earning this much, and what I have that has been affected is only earning this much, then you can see that there's a difference there. So it takes two things. It takes good business records, which I always ask for from our clients right from the get-go, to a very good expert that can tell me very clearly what the losses may or may not be. Yeah.
Thank you for the talk. You mentioned fear of litigation and concept. Like let's not go to court, but win or lose. Instead, we're like a long-term relationship with certain people in the society that's settled out of this system. So how do you reconcile this?
It's true. It happens. I tell this to them. I tell them two things. Number one, again, I would say 20 cases, 19 will never ever see the inside of a courtroom. So it's the reassurance part right there, right from the get-go. And I also tell them that it's not like you're playing chicken or you're playing bluff, but you have to push your case as if you were going to prepare for court. But number three, I tell them, I'm just your lawyer. I'm not here to make your decisions for you. I can't say yes or no. All that I can do is give you my advice. So sometimes I really have to control the situation where it's just like, okay, if I take you here, if your case is worth this much and we get to the 80, 85% mark or even higher, I really think you should take this, right? Or conversely, if something bad has happened and I'm just like, okay, this is what I need to get you out of this really sticky situation, right? This is what we're gonna do. So it's really based upon the trust between your client and the lawyer. They really have to trust you that you're out there for their interests. Yeah. Any other questions? Please. Mm-hmm. For sure, so especially if I'm acting for somebody in a corporate realm, I make sure the person that I'm talking to is actually part of that corporation. So whether they are their most senior employee, whether they're the director, whether they're the president, whatever, whatnot. And so that is something that you can find in probably their corporate records. You can check that online, business cards, whatever, whatnot. But if I have somebody call me and say, hey, I want to know more, I'm a part of this, I don't say anything right away. So I completely suss them out. I might go back to my contact person and say, hey, who is this individual? They called me. Is this person legit or not? And they might say, oh yeah, he's a silent partner from whatever. And I was just like, okay, do you allow me to talk to him about this? And if they say yes, then I was just like, well, you can, or I can. But if they say no, then no, I'm never taking a call from that individual ever again. Yes.
I was wondering what strategy you have for hacking the personal life, not on the work leaving.
It's like I'd sit here a little bit in a position of privilege because I've been doing this for, like 19 years now. I sit here as like a partner in my law firm. So frankly, I can say it's easier for me now than when I was like a junior associate. And I would say this, I would say a lot of things are, the first time you do something, it's gonna be really hard. And it's probably gonna take you 2 hours to do an assignment. But by the time you do it for the fourth or fifth time, it's probably gonna take you 15 minutes, right? So it's sort of getting used to the beginning of like this steep learning curve and then setting it out at the end. Me personally, like I have certain rules that I try my best to abide by. This is me. So when it comes to a trial, our policy at our law firm is we always double up. So I always bring in somebody else to assist. And that's for learning purposes, that's for mentorship, that's also to, that's also for the benefit of the client as well. I always tell who I'm working with that after trial, or if we're eating, either it's lunch or if it's dinner, we don't talk about the case. So for that 1 hour or so where we're just having a meal, we're not talking about what happened today, we're not talking about what's gonna happen tomorrow, we're literally just gonna enjoy our time together. And if this trial is more than a week, so it lasts, so there's like a weekend involved in it, I always make room for like a full half, at least half a Saturday or half a Sunday to do something for myself. So instead of showing up at the office at 8 o'clock, I'll show up later on in the afternoon, spend some time with family and friends, go out for a bike ride, whatever I feel like doing. But again, just compartmentalizing, right? That's in a trial. Everyday life, I just try to remember that there's other people involved in my life. There's obviously family. There's obviously my friends. There's obviously my social circle. There's other things that I do. So I try not to identify myself as I'm Doug the lawyer. I'm Doug, I'm a lot of other things too. I think that has helped. Yeah, did I answer your question?
Yeah.
Perfect, thank you. Yeah. Sure. I have ran close to 20 in 19 years. That goes to say how little, how it doesn't really happen, right? So both judge and jury. Yeah, it's more things get, again, courts are aware of this, government is aware of this, lawyers are aware of this. What you see on TV is not what happens in real life, right? It might happen more in a criminal setting, but definitely less when it comes to like Supreme Court of BC civil litigation. So I do not go to a trial like every day, at least every month. A lot of our cases settle just through phone calls, emails, negotiations. A lot of it is done through mediations. So we hire both sides, appoint and hire a mediator to basically help us broker a deal. Both sides might not be completely happy when it ends. You know, you might have to give up something to get what you got, but both sides also recognize how expensive going forward that might be too. So a lot of being a litigator, again, trial work is really important. Negotiation and listening it's equally as important. Yeah.
Yeah, so I actually have quite a few questions.
For sure.
So I guess my first question is kind of off the back of the question that was just asked. So I guess let me preface this by saying I have no litigation background. As I often tell my students, I had no knowledge whatsoever about litigation, the litigation process. That's not strictly true, but everything you're saying about how rare or how uncommon it is to go to trial, I mean, that's totally consistent with everything I've heard from other lawyers. It's consistent to what, my law professors told me in law school. And so when you're saying, it sounds like you only do about like one trial a year on average. Mm-hmm. I'm curious, like why would a case go to trial? Is it and I can guess a couple of reasons. I mean, one might be just because you have someone who's like really emotionally invested in the trial. And I guess the other I might guess does it happen because the parties have like very sort of different expected valuations of the outcome of the case? Does that make it more likely to go to trial?
Both are exactly right.
Okay.
Yeah. So to talk about
I know more about litigation than I thought.
You do, for sure. So to talk about the first one, yeah. So that's actually pretty dangerous. So sometimes when I have a client who says, you know what, it's out of principle. I want to go no matter what. I want to go to hurt this person. I want to go because I want my day in court. Those are honestly a little bit scary because there are consequences attached to a decision, especially a poorly made decision. There's a time consequence, right? So a trial is not right away. There are at least, I would say, 5 days, if not 2 weeks. And then you have to wait probably more than 3 months for a decision. So it's not like TV. A judge doesn't give you the ruling, a jury does, but a judge doesn't give you the ruling right away. It takes about at least 3 months, I would say. And yes, the second one is the one that's the more likely scenario, where both sides are just literally so far apart. So I might have opposing counsel and saying, Doug's not going to win this case. A judge is not going to believe him. The plaintiff can't prove their case. They're going to be terrible in court. The evidence doesn't back him up. The law doesn't back him up. You know what? We're just going to run it. Let them prove themselves, right? We might be in a position where we have a great case. Our evidence matches up. Our experts are going to go. We have an extremely credible witness. We got enough time. And they just might not see that, right? So what we see on the other side, it's also business decisions too. So a lot of the time people are weighing, okay, if we have to pay, if this trial is coming up, how much is it going to cost me? How much is it going to cost me to pay my lawyer for preparation, for attendance? And okay, if it's going to cost me X, should I just give a little bit more now to prevent this from going forward, right? So, but I would say in most cases, both sides just don't see eye to eye. And it does happen. Those are the more normal cases that we get.
Yeah, I mean, like what partly kind of informs my question is like I have a transactional background, and like certainly in the world of transactional practice, like I worked in corporate transactions. When you're working with business clients, you're trying to do business deals. they are like, not only they, but also the lawyers that represent them are very averse to litigation. That's always considered like the absolute, worst case scenario. And often when there is I remember when I was in practice, whenever there was a file that would end up going into litigation, it was because somebody involved, like some client, either our client or the other client, was basically like unprofessional and had like a real, like some crazy emotional investment in something. But it was always considered like something you would always like, you know, you would counsel your clients to avoid litigation, but like the business clients themselves, like, and actually, so this leads to another question I have. So the other question I had is, you mentioned a few things, and then some of the students who asked questions mentioned a few things, kind of in this specific context of representing ethnic clients, in your case, representing Chinese clients, about, for example, not wanting to, damage one's reputation in the community, or not wanting to like maybe sever relationships. In my experience, that's just very true in the business world writ large, is people have the exact same concerns. And beyond the kind of like the language issues that you'd mentioned, a lot of the, sort of, like the hand holding and like the concerns clients might have, they seem like the kinds of issues you might encounter with clients from all sorts of backgrounds, right? Clients from like, whatever cultural or ethnic background. So I was just wondering, in your experience, like, have you noticed like, I know you said you focus mostly on Chinese clients, but have you noticed like a real like difference, or is it like, is it something that you think is really specific to the Chinese clientele that you represent, or like these issues that like all lawyers have to deal with?
I would say these are issues that all lawyers have to deal with, right? There is, being a lawyer, it's a service industry, right? So we're here to provide a service. I'm no different than the retail store that I act for. If I don't have a client coming through my door, which I provided good service on, the lights don't turn on in my law firm, right? So no, I would say doing a lot of these things, it's providing that service to begin with. But in terms of dealing with a specific clientele, I do find myself basically with a little bit more handholding, I would say, a little bit more of the finer details. And because they didn't, my guess, they didn't grow up with it, right? So there's no TV show that they can sort of reference or refer to. There's no movie or anything like that to get an idea what a courtroom looks like, right? There's a background there that you sort of have to keep in the back of your mind. So every client I've had, regardless of background, gender, race, whatever, whatnot, they're going to be scared, or they're going to be fearful, they're going to be stressed out before their examination or discovery. They've never done this before, right? But I can say that for some things, I have noticed that are different when dealing with an ethnic clientele, though.
Yeah, that totally makes sense. And then I guess the last question, which was related, because you mentioned that you've kind of, it sounds like you've sort of specialized in this kind of niche litigation practice, focusing on Chinese clientele. So this is a bit of a personal question, but I think it's relevant. So you mentioned that you speak both Cantonese and Mandarin, but your parents are from Hong Kong. So did they speak Mandarin, or is that something that you actually developed for professional reasons?
This is like, and something they don't teach in law school here. It's something they didn't teach me when I was here. There's a very fine marketing component to running a law practice. Especially if you're at a smaller firm, right? Clients don't just come and see me. I'm not a doctor, I'm not a teacher. So it's part of building my own personal brand, and it's part of building myself and to market myself, right? So yeah, my first language was Cantonese. I spoke that. That's my first ever language. I picked up English shortly afterwards. And obviously I was missing this component. A lot of my clients who were coming to see me, they were Mandarin speakers. And I was just like, okay, if my brand is going to focus on this particular community, this might be something that I need to learn more. And yeah, I did. So I remember during my vacations, so I would get X amount of weeks off at my law firm when I was an associate. I actually spent, I think, like 2 weeks out of the year, like going to like school here and taking these like intensive Mandarin courses where you're here Monday to Friday. So instead of going somewhere, I'd be literally like you guys coming to school during the summer. I would also hire a private tutor, for instance. And again, they're not there to teach me like literature. They're not there to teach me how to like write an essay, right? It's more of like how to converse, right? So yeah, it was something that I did pick up, and I had to in order to hopefully further clientele and business for myself. Yeah.
Also marketing. So how do you market yourself to your clients for other than selling for
For sure. Yeah. So for me, like I was very, Hammerco is the only place I've ever worked. So I'm kind of like a unicorn. I have the opportunity to start and probably end my career at the same exact place, right? That does not happen nowadays. And I was lucky to be in a law firm that really encouraged marketing and self-development and promotion of your brand, right? And so for me, I was just like, hey, I can speak both languages. I can speak English and Cantonese. I went to school here, for instance. I have ties here. It's what can I do? How can I make myself this go-to lawyer amongst my community for a specific practice area? So yeah, it was not just being on radio and being on media. I was also like, I joined certain organizations. So I joined organizations amongst my community that were prominent. I was a board member on a couple ones. I chaired, those fancy galas where people raise money for, I chaired 4 of those, and then we raised more than $2 million, right? So, but things that get you out there in the public. What else would there be? There were some print ads, like those really weren't for business. Those were just more for like, again, putting your face out there. But I would say literally the bulk of it came from referrals. The bulk of my business comes from direct referrals. I got your name through someone. You are currently the lawyer for X. That's how, or can you help this person, right? That's where, so it just came from just work. Mm-hmm.
Yes, I just kind of thought of another question. So I'm just kind of curious, and I don't know if you can answer this, but you've described your own practice, which is fascinating, and how you've kind of branded yourself and marketed yourself. And it sounds like it's something you like literally learned Mandarin. I mean, it sounds like something you put a lot of effort into. I'm just curious, like among like the community of like litigator, like just because the like Metro Vancouver, like the city of Vancouver is like such a diverse place. Like it's a really, really diverse city. Is that common? Like, do you know other lawyers who are like, oh yeah, like I've really marketed myself to like the Punjabi community, or I've really marketed myself to the Persian community, and that's kind of their niche? Is that like a common strategy, or is that more like a one-off that you did?
100%. It's a common
Oh,
strategy.
okay.
Yeah, for sure. There are lawyers definitely, not just for a specific ethnic group, but for others as well. They might practice in a certain area of law even, right? So even in solicitor's work, if there's a lot of like, say, like international transactions, for example, that's one. If they have background by being educated in a foreign school, that might help too. If they're called in another place, in another country, in another jurisdiction, yeah, definitely, right? That's also where like the network really helps out. So my clients, they don't just come from current clients or past clients, they also come from other lawyers, right? They come from those where it's just like, Doug, I don't do this area of law. You do. Can you look into this case? Doug, I have trouble, we have trouble finding a translator. We have trouble communicating. Can you take this on? There's things that I don't do, right? Like if somebody asks, Doug, can you help me with this criminal case? I refer them to one of my best friends who I went to law school with, like literally. So that happens a lot amongst the legal community too. Yeah, go ahead. Yeah.
For additional loads of billable times that handle it. How do you and with potential financial stress for the client, especially if they're small business or an individual?
That's a really good question, right? I'm upfront. Yeah, totally. So I'm just like, there's a likelihood that we'll have to pay for a translator's costs. Are you okay with this? But in honest, we need this to prove your case. So I'm pretty upfront with that. But I also, if I'm billing hourly, so if I'm charging the client based on my time, I also review my time too. So if it's something where it doesn't like move their file forward, or it's just literally like client service, I don't bill them for that time. No, it's again, like just trying to be transparent, right? It's just like, these are things that I will need. These are costs coming forward. And also there's the potential chance of if we do succeed in court, you're going to get these translation costs back at least, right? Yeah.
The point of transparency,
Mhm.
it seems like one might not always know in the beginning what the scope of work is going to be, and then eventually going forward, if the client wasn't expecting those costs, you feel like you did something bad with them. Is that something that you face, and how do you deal with that?
Yeah, that happens all the time. Like I wouldn't say all the time, but it does happen. Like you are going to get client complaints as part of your job. It's a service industry, right? So what I do with them is you try to be reasonable, right? And it's just like, okay, these were told up front, or this is my cost. But I also, you have to respect your own work too, right? So I'm not going to cut my time or die down my time if I know that I did a really good job for someone, if I really did advance their cases. I tell this to my associates all the time. It's, if I have 20 clients, 16 of those would appreciate the things that I do. And they'll say, Doug, you did a great job. You know what, we're gonna refer everybody to you afterwards. I would say one of those would absolutely love you. All right. Anything that ever happens to them in their life, they will call you first. You're the first person in their Rolodex. You're going to have two people where they just have this, the mentality of, all right, well, yeah, you did it. You know what? I could have done it too. You know, you didn't really help out that much. You weren't a big part of it, right? You're always going to have that one person, regardless that anything that has happened, regardless of how well you did on that case, they're going to complain. Right? They're going to say, you didn't do this. What about this? You're too expensive. You didn't charge me, or you charged me this, or you didn't say this, and that didn't help my case. In fact, you hurt my case, Doug. Right? So you're always going to have like that one complainer that you kind of have to deal with, and you have to deal with it in a smooth sort of client relation sort of way, but you have to hold your own dignity at the same time. Yeah, so the best way to deal with those, have every single thing written. Right? So you can refer back to your emails that you sent this person that we talked about this issue on this day. I told you how much it was going to cost. I told you what the risks are. I told you what you should expect if this case goes to court. This was my advice, right? So you refer back. You're kind of protecting yourself. You know, if they were to make a complaint or something like that, you know, you have that all there. Go ahead. To answer, I don't know the answer to the first one. There's 14,000 called lawyers in BC. Unfortunately, there's nothing there that basically says what languages you speak or anything like that. So unfortunately, I do not know how many Mandarin or Cantonese speaking trial lawyers are out there, right? I'm sorry, your second question was? I wouldn't say it's an advantage, you know, that would be me, you know, giving a disservice to my fellow colleagues who are equally, if not better at me at some things, right? It's part of something that I'm able to do, right? But to answer that question, just do really good work, right? So like, just be really good at what you do, right? Be honest with your clients, be respectful to opposing counsel, right? And your reputation will eventually carry itself, for sure. Yeah.
Okay, well, We've got a class coming in about 10 minutes, so now's the time to exit the classroom. But thank you so much, Doug. That was a great talk. I learned a lot, and we had really terrific questions. So
Yeah,
thank you to everyone here who came and asked great questions.
Yeah.
All right, so maybe another round of applause for Doug and
Thank
great
you.
event.
Great.